Our speech today will be about non-traditional trademarks. Our guest speaker is Mr. Craig Morris, who works within the Office of the Commissioner for the Trademarks in the USPTO. Mr. Morris has been with the USPTO since 1983, previously serving as Law Office Examining Attorney, Senior Attorney, and currently Mr. Morris is the Managing Attorney for Trademark Educational Outreach, spearheading the effort for increasing the USPTO education activities in the area of trademark. So, welcome, Mr. Morris.
Thank you very much. So I can't really jump right into non-traditional marks without at least starting at the most basic point, which I assume most of you are going to be familiar with, and that simply is, what is a trademark? So there's kind of the classic definition of what a mark is: word, phrase, symbol, or design, combination thereof, that distinguishes the goods or services from one company versus another. So I threw in the word services. Obviously, the trademark is for goods. Service mark is for services, but usually, just for simplicity, when I use the word mark or trademark, that actually is going to cover services as well. What I really want to highlight here is the very first word of that definition, generally. Because for us to transition to non-traditional marks, you're going to have to figure out, well, how does that fit in? So it is coming from the classic definition. And of course, for the classic definition, we have Coca-Cola, just a regular word mark in the stylized format, considered one of the most famous marks in the world. For a long time, actually, it was considered the most famous. Now it's been overtaken by Apple. But it's certainly good in terms of just showing what a traditional trademark would be. Now, why is a trademark even important? Well, it's a valuable business asset in and of itself, and also when licensed. Keeping with that Coca-Cola theme, an executive of the Coca-Cola company was once asked, what do you consider your company's most valuable asset to be? He said, without question, it is our registered trademark. We could lose everything that we have as a company, be able to build again as long as we still have that registered mark. So clearly, a very valuable business asset. We're going to talk about that in terms of, again, today, non-traditional marks, and then I'll conclude with a reference to licensing and how licensing fits in to this overall picture. So non-traditional marks, this list actually keeps growing. We're going to look at each of these, but you can see here all the different possible types of non-traditional marks. Color, shape and color, sound, scent, motion, feel, hologram, and finally taste. So we're going to go through examples of all of these. If at any point you have a question, please raise your hand. I will repeat the question so we can hopefully capture that on the tape, but I'd like to address whatever your concerns might be. So our first area, color as trademark. What we're actually talking about here is color as the overall mark. And our first example is the UPS brown truck for delivery of personal property, where they're claiming the color brown for the entire truck. Now, throughout this presentation, I'm going to balance kind of the actual visual with what appears in the USPTO registration certificate, because you have to see, well, how does the USPTO handle these things? So here's the certificate for UPS, and you can see there's the delineation of a truck. You might wonder, okay, well, what are all the lines on that truck? Well, years ago, the only way for us to show color was through a lining system. So here, those lines in that direction, that corresponds to the color brown. The rest of the truck, it's in dotted lines because what UPS is saying is we're only claiming the color brown as our mark. We're certainly not claiming the configuration of a truck. And so in order to show that we're not claiming the truck, we have to show that in dotted lines. You're also going to see there, if you can see on this particular screen, it says section and then 2F. Well, what does that mean? Well, that means that in order for this to register, UPS had to establish that the mark had acquired distinctiveness. That's the provision of the statute that says it was not considered inherently distinctive. You have to show us that, in fact, over time, through use, for example, people now recognize this as a mark, and if you can establish that, we will allow registration, but particularly under the provision of Section 2F. So that's our first example. Next example is the Duracell copper top battery, where again, they're claiming the top portion of that battery. Again, identifying that portion is what they claim as the mark. Now here, this one was not under Section 2F. Sometimes difficult when you don't have the same examining attorney handling every single color mark, for example. Sometimes we're not totally consistent. So I can't specifically tell you, well, why was the first example under 2F, yet this one is not? I don't know if there was a difference of opinion or they thought it wasn't just necessary. This one, just straight up on the principal register. Here, the Levi's red tab. Now, you need to have a little bit of history for this to know that it was actually way back in the 1890s that it went into the public domain in terms of people making denim pants, okay, jeans, as we would say today. The problem really came to a head in the 1930s when the Levi Strauss company realized they simply were not able to really tell their jeans from other jeans because particularly when folded, they all looked the same. Someone within the company said, you know, what if we added something that would really make it distinguishable? And what they came up with is that little red tab there on the side of the pocket. So in the 1930s, they said, we have solved our problem, and in fact, our solution was so good, we are going to promote this. So in their advertisements, particularly in the 1940s and the 1950s, they said, look for the red tab, okay? Really tying together that that red tab really means Levi. Now, again, you can see the problem that we have at the USPTO. We are relying on a drawing in order to convey what the mark is. If I looked at that drawing without knowing what the example was, I'm not sure I could really figure out that that is a red tab. Again, it's lined for the color red. You can kind of get when you read the mark description, but it's a little difficult, okay? For years we had this problem that we were relying on really an archaic way of representing what the mark is. Shown together, I think it's pretty easy to figure out, but just looking at the registration itself, I think that is a little difficult. Tiffany blue. Probably familiar with Tiffany. You might wonder, well, why did they even come up with this as their signature color? Again, a little bit of history on this. Apparently back in the 19th century, it was very popular to give turquoise as jewelry. And so they said, you know, we want to go with that theme. So they have gone with what's now really called Tiffany blue, but it kind of originated from the turquoise color. And again, we're going to see here is that box. It is lined for that color blue. Now, people sometimes ask, well, under this lining schematic, you know, how would you know that that was a turquoise blue versus a royal blue versus a blue-green? We really have no way to identify that. Some people have said, well, why didn't you go with the Pantone system, where you could be very precise. We never wanted to go that way. We didn't want to have that level of detail, but again, I think it's a little difficult if you would look at that registration certificate without really being able to visualize, oh, well, that's Tiffany blue. I'm not sure you would be able to figure out what that is. We're going to see in a few minutes that fortunately we were able to change that. Next, Owens Corning pink insulation. Now, does anyone know why this is really a seminal case for the USPTO? Have any of you studied the Owens Corning case? Well, put everyone on the same playing field. Let me discuss that. Okay? So Owens Corning applied for the color pink for insulation. My office actually refused to register that. We said that that would not be perceived as a mark. It was actually appealed to the Federal Circuit, and we were reversed. In part, okay, show you again just the schematic. What I really want to show you is this character. The people at Owens Corning actually approached this in a very good way. They knew that there was going to be a problem, so they came up with a marketing campaign using the Pink Panther, because they knew that they would have to create the association of this character, the color pink, and their product all tied to Owens Corning. The Federal Circuit agreed with them. The Federal Circuit said, yes, the public will in fact recognize, because of your marketing efforts, the color pink as a trademark. This is important because this was the very first mark actually registered as a color mark. Okay, so this kind of sets the whole stage for any color marks after this. Very important. But again, they had the advantage of marketing people that knew, let's come up with a clever campaign that really gets the color pink in the minds of the consuming public. Here next we have Elmer's glue. I'm showing this not so much for this visual, but for the registration certificate. This is where we're first seeing the certificate actually being in color. So rather than having that top of the glue bottle line for the color orange, we're able to see right here the color orange is what is being claimed as the mark. Again, under section 2F. Finally, in this group, the John Deere green and yellow. Again, we know that this is a later registration because we look at the certificate clearly in color, but again, the dotted line signifying they're not claiming the shape of the tractor as part of the mark, simply the placement of the colors green and yellow. You can also see in terms of just the overall layout of that certificate. At some point we went a little more fancy. We have the USPTO seal there, and we have the signature of the commissioner, making it an overall more attractive certificate. Just as an aside, my office is trying to move in the direction of doing everything electronically. This is one area where we're still having a little bit of trouble because under our statute, it indicates that all registration certificates will be affixed with an official gold seal. We have a special machine that affixes this gold seal. Well, electronic environment, how is a gold seal going to exist? So we're trying to figure out whether we can still meet the terms of our statute, but move everything into being totally electronic. So that's the first area, is simply color itself as the mark. Now we're going to go to a combination. This is shape and color. So our first example, the Febrary plaid that I'm sure most of you are familiar with. Again, going from that actual image to this, again, you have to kind of read everything to come up with the notion of, okay, well, how is this being used? I think in the abstract, again, it's a little difficult to say, oh, I know what that is. That must be the Febrary plaid. Okay, but this is the representation on the certificate. The next, for the Tabasco sauce bottle, I think this one is a little interesting because we have two things going on here. So again, this is line for color, but let me go back. So we have the color red coming from the actual top of the bottle, but they're also claiming color red because the contents of the bottle, that content is red. So coming through the glass, clearly you're seeing the color red. So they're claiming that overall thing. One, the molded plastic is red for the top, but because the content is red, they're saying that's also being claimed as color. Keeping with red, here's the Etch-a-Sketch. I imagine almost all of you, unless I kind of look over on this side maybe, you're too young for the Etch-a-Sketch. But no, you're saying no? Okay, well that's good. Because growing up, this was such a huge thing, the Etch-a-Sketch. 150 million of these apparently have been sold. So I think it's still kind of a fun deal. And again, here they're saying we're claiming color for all of that in that particular shape, again, under Section 2F. I haven't mentioned this before, and you'd have to be looking very carefully at this. On our registration certificates, we list the examining attorney, in part to give a sense of pride and ownership of the work that you're doing. Many of the color marks you're going to see a particular examining attorney, Ms. Teresa Rupp. That's because color marks are considered to be more difficult because you don't see them all the time, and so we designated one attorney initially to handle these, so for consistency. So you'll see that name on a lot of these color marks. This will become a little more relevant in a few minutes. So the checkerboard design for shoes. They're showing on the certificate again. And here is Adidas. I'm sure you're familiar with that, the 3 stripes for Adidas. Now, here's the Perrier water bottle. I want to contrast this with that Tabasco bottle, where here they're claiming the color green because that actually is the color of the glass, not the product itself. So the Tabasco, we had red claimed because that was the red Tabasco sauce coming through the glass. Here, the color green, that's the bottle itself. Again, older registration, the lining for the color green. So that's where we were combining both shape and color. Now we're going to move to the next area, simply shape as the trademark. So here, goldfish crackers. Now, I said that all the registration certificates have a name. I actually, when I was reviewing the material, I didn't realize this was mine. That I did the gold. I mean, this should have been like the highlight of my career, and I forgot about it. So there it is. Here, the little VW bug. Well, if you all knew the Etch-a-Sketch, certainly you know the lava light then, okay? So here's the lava light. I think what is really missing here is when you get to the registration, when you read what it's for, ornamental lamps containing liquid globules which circulate when the lamp is in operation. You're not getting that effect of those globules floating around there, okay? That's the fun part of the lava lamp. But in terms of the shape itself, That's what the trademark is. The Christian Dior J'adore bottle. This is, I think, a very beautiful bottle. I think it's certainly lost in translation when you look at the certificate. I don't think you're, getting that effect, but that's the best that they could do there. Similarly, we have the Mrs. Butterworth bottle. I think she's kind of happy. I think this is kind of sad. And finally, one of the most important, again, tying back to the Coca-Cola theme, here's the Coca-Cola bottle. Just a history on that. The designer actually said that he was inspired by the cocoa pod. I've never seen a cocoa pod. I don't think that's what it would look like, but that's what he said, that he wanted to make that contour shape of the bottle to kind of resemble the cocoa pod. This, I think, is not a good representation, but it was kind of even lost in trying to reproduce that. And our last two shapes, the Dustbuster portable vacuum. And here we have the little igloo container. And that one, I think, is actually a fairly good representation. This, I think, is fascinating. This is one of our more recent ones. So you're taking, a little shape, a little portable dustbuster or an igloo container. Now we are going to a whole building that sits right in downtown Manhattan. Okay, so they were able to get a trademark for the entire shape of this building. Again, very impressive. I was just in New York last week and walked past this. It really is quite impressive. Again, I think that's a little lost when you try to figure out from the certificate, how visually does that really look. But again, this is one of our more recent registrations. So we're ready for the next category. Sound as trademark. Again, something that's possible to be registered. Now, unlike the other ones where I said most of them are under Section 2F, where they have to show acquired distinctiveness, our sound marks, more likely than not, are not going to be under 2F. For a sound mark, you really have to rely on the description of the mark. So is anyone able to read this description and tell me who the owner of this mark is? Okay, I heard it. NBC. Okay, these are the famous NBC chimes. Do, do, do. Okay, that is what that whole description is trying to tell you. Okay, you kind of have to know something about music to know, well, what would that actually sound like? But that's what you have to be able to do with the sound mark. Here's another one. Who is this? MGM. Very good. Okay, so the beginning of that movie, that lion roaring, you know that is MGM. Now, I will point out, not everyone is successful. That's why I'm not going to give an example here. Not everyone is successful in registering a sound mark. Harley Davidson wanted to register the sound of a motorcycle engine revving. They spent 6 years in my office trying to get that registered, and they finally gave up on that. Primarily because other motorcycle manufacturers basically said, no one in the public is in fact going to register that sound as coming exclusively from Harley Davidson. And if you can't establish that, well, then you cannot register that as the trademark. Okay, so certainly marks that are sound marks are registrable, but you are not guaranteed that you'll be able to register. Next category is sent as a trademark. We don't have too many of these. I really want to highlight what was the actual first mark that was registered. I think this kind of description is interesting. Sewing thread and embroidery yarn having a high impact, fresh floral fragrance reminiscent of plumeria blossoms. I have no idea what that smells like, okay? I did find a picture. This is the plumeria blossom, but I just found it somewhat interesting that the applicant felt inclined having a high impact, fresh, kind of overkill, I think, but I think she was concerned, wow, this is really breaking new law. I really want to make sure that I'm establishing that this is unique. So I think in her description, that's why the wording is kind of over the top there, really trying to say, this smell people are really going to recognize. Obviously, thread and yarn didn't have to have a smell, so we acknowledged that in picking thread or yarn up, having a scent, well, it's going to establish that this is a source identifier. As such, it is a trademark, so this was the first scent mark that we did register. More and more, we are seeing motion as marks. Again, this gets a little lost in translation because we're not going to be able to show what the actual motion is. You have to visualize. So here's one where they're showing, these are kind of the progressions of the movement. So if you can visualize, it kind of starts there at the top, then letters come in, then something there in the bottom, then, okay. It's the overall progression there. And you have to almost view it in the context of the description. When you have both of them together, although this description, in the same way that I thought that scent one was over the top, there's a lot going on in that description, okay? But you have to be able to visualize from that description what that motion actually is. And here's the same, again, there's stuff going on with the beams of light. There's wording that comes in, beginning of a motion picture, kind of tying motion and motion picture. It's a coincidence. But if you read through that, it does describe how there's flashing lights against the background of sky and clouds, and then it pans down, the lady on the pedestal, the word Columbia, okay? Unfortunately, we don't have in the record that you can just go and see, oh, here's the true motion. Okay? This is the information that's going to be on the certificate. And I didn't do what I did elsewhere where I showed the actual certificate because the little drawing by hand, if we thought they were bad for some of those others, they're really bad for these motion marks. So I just want to use kind of that image of her in front of the clouds with the description, again, trying to visualize, okay, well, how does that actually appear at the beginning of the motion picture? Now we're getting into even a more unusual area. Again, this keeps expanding. We thought we were doing something really unique when we started registering color marks and shape marks and motion marks. Now we're kind of heading into new territory because people are saying, well, what about this as a mark? So here is the category of feel as trademark. Here's the example. Now, when I first saw this, I was really confused because all I was seeing was that top image, and I thought, okay, well, that's a basketball. How is that functioning as a trademark? And it wasn't until I saw what the actual product was. So that opens up, and inside is where the actual product is. But what they're really saying, and this was in the description of the mark, that it's pebble grained and it has a rubberized soft touch, again, consistent with what a basketball would be. But they're really saying, we're not claiming that it's in the shape of this, we're actually now going for the texture of that. So again, just feel as trademark. Here's another one that I think is very interesting. So the mark is actually for Stevie Wonder, but this is the representation of his name in Braille. Okay, so obviously that's going to be feel for the trademark. I think it's also interesting in terms of, and I don't know if it was in this specific applications, because Stevie Wonder has had several. So you're probably aware we have a signature requirement for the application, and this was back still for Stevie Wonder's era doing paper applications. His signature consisted of his fingerprint. Okay? And so we had to look back at the Uniform Commercial Code to say, well, is this acceptable as a signature? And by the code, a signature can be whatever the signatory has adopted as his or her signature. That serves the function of a signature. And you think back, pirates, the X, they're saying that, well, it's really anything that can be a signature. So we said, if that's what Stevie Wonder wants to use as a signature, we have to accept that. This then morphed later on into our electronic world, where we had to come up with a way of saying, well, how will the electronic form be signed? And we went with the format of simply typing in a / followed by any alphanumeric combination of the signatory's choosing, ending with a /. We said that is what the signatory has adopted. That is acceptable to us as a signature. Now, even moving into areas beyond what we've looked at, what about a hologram as a trademark? Well, we said, in the same way that other things identify source, there's no reason that a hologram cannot be a trademark. And here we have American Express, hologram in the middle there. Now, to be honest, I was provided this image from someone else's presentation. I had to wonder, is that like a real number? It looks like a real American Express card, so I don't know. So I'm going to quickly move to the next slide, just in case. So taste as trademark. We actually have to look at this slide. So we did have an application for a taste mark, and it was specifically for pharmaceuticals for human use, namely antidepressants. This did go to the Trademark Trial and Appeal Board, and they affirmed the refusal on the ground that taste failed to function as a mark. Well, that's in and of itself okay, but what was more interesting to us going forward, there was nothing in the opinion that indicated that taste could never function. Okay, so right now we don't have any taste marks registered, but we have no indication from the appeal board that there would never be a taste mark registered. In the same way, and again, we've seen a progression here of marks that, well, we were surprised at the outset, again, starting with Owens Corning, registering the color pink. That started taking us in a new direction. So we thought, okay, we'll deal with color marks. And then suddenly we're dealing with shape and color. And then suddenly shape alone. And we thought, okay, well, we've pretty much seen all there is to see. And then suddenly there were motion marks. There were sound marks, the hologram. We don't know where this is taking us. You always have to go back to the classic definition of a trademark. It's really anything that serves to identify the source of goods or services as distinguished from the goods or services coming from a different source. Who knows what that might be in the future? It's really hard for us to predict. We're almost anxious to see what will be the next big thing. All of these categories keep expanding, but they're existing categories. We're going to be interested to see, well, what is the next category? What is that category that we never projected could possibly be a mark, but lo and behold, someone comes in, applies for something that we have to step back and say, well, does that or does that not serve the function of a mark? And if the answer is yes, if it does identify source, then we're going to have to say, wow, I didn't think in my lifetime that I would possibly see this, but here is a new category of marks. Maybe one of you will be the first to think of an absolute new category for a mark. So that's kind of just the overview of non-traditional marks. I then want to kind of tie in, and it's going to tie in really trademarks, not specifically non-traditional marks. But how does this fit into licensing? Well, licensing obviously is going to have possible advantages and disadvantages. You're probably aware, well, how does this even come up in the construct of trademarks? Well, again, a trademark is an asset, which means that it can be licensed. In the context of the licensor is still going to hold the actual rights in the trademark, and the licensee is going to pay for using that mark. Okay, so that's just the general construct. Trademarks are a little specific in terms of it's very important that any licensing agreement very clearly sets out what the expectations are. And what do I mean by that? Well, if we think what the trademark does, it's really not only the source identifier, but it's an indication of quality. That's really what the trademark does. It tells you the quality of the goods or services. Each time when you buy a product under a particular trademark or use a service under a particular service mark, you expect the same level of quality. You know that each time you go to a McDonald's restaurant, it's going to taste the same because it's the same mark. So what might be advantages of licensing? Well, for the owner of that mark, they may not have to do as much in terms of they're no longer interested in the manufacturing aspect of the product. They're willing to say, I'm going to grant you a license because now you're going to take over the manufacturing. Maybe that's one less headache for me as the owner of the mark. I'm still the owner of the mark, but now you're going to take on the role and responsibility of producing goods under that particular mark. That's good for me because I no longer want to worry about that. It might also allow you're able to expand into areas maybe I can't get into as easily. Maybe you're in a part of the world that you have more familiarity with how things operate in that part of the world. So as the licensee, you're able to grow the business, which I could not do. Okay, so that's advantageous to me. So there are advantages, but there are possible disadvantages. One of the possible disadvantages is not only are you growing the business, but in fact you become my competitor. You decide to cannibalize my business, and in fact I end up losing business. Or the reality is, I thought I was putting myself in a good position. I thought I was going to make more money because I didn't have to worry about things such as manufacturing. That is not always the case. Through the license agreement, the reality is I still could have done better if I kept everything contained in myself. Sometimes you don't know that until you enter into the agreement. Probably the most important potential disadvantage, again, understanding what the license agreement really says, the potential disadvantage is that the licensee is not living up to their part of the bargain. The licensee initially is saying, I understand what your quality measures are. So I'm going to make sure that I, in fact, meet those standards. The reality is not all licensees will do that. The quality starts going down. Then that hurts your reputation. That hurts your possible goodwill because people are no longer interested in buying that product or using that service because the quality simply is not there. Again, a good license agreement is always going to clearly spell out those kind of things, and it's up to the owner, the licensor, to make sure that in fact all of those quality steps are still being taken. And sometimes there can be a breach there. That's how the owner can get out of that. If the owner is saying, licensee, you had agreed that you would do X, Y, and Z to make sure that quality was up to the standard that I expected. You are no longer doing that. We're going to have to end our relationship. Because at the end of the day, if that relationship continues and the quality is not there, that's very harmful. So when things are done properly, clearly potential advantages. When they're not done properly, there may be serious disadvantages. So that's how, again, not specifically for non-traditional marks, but trademarks in general, a very possible lucrative area for any owner of the mark to license that out, but there are potential pitfalls. That's all I have on the topic. It's not a topic I normally cover, so I can't go on, but I did want to leave time for questions, whether it be on non-traditional marks or on trademarks in general. Some of you, I think, have a stronger background in trademarks than others, so if anyone has a question, I'll certainly field at this time.
Now that the law has become better known in places like here in Europe, do you expect a rapid increase in applications for these non-traditional marks, especially like 3D marks or hologram marks, or do you expect companies to still be kind of hesitant to enter this area?
Okay, so his question was, as these types of marks become more known, do we expect to see the number of these types of applications to increase? Kind of paraphrasing, but I think that was the gist of the question. I would say without question, yes. We know just from what we're receiving now that the numbers are increasing. I can't give you, actual number statistics, but each year, companies are always looking for the next big thing, okay? Regular trademarks, the Coca-Cola stylized mark, that's existed for so long. Why would you get excited about that? Anyone can do that. Can anyone build a clear box in the middle of Manhattan and have that recognized as a trademark? That's exciting. That builds buzz. So I think we're definitely going to see more and more companies exploring the option of saying, we could do this for a mark, but now since we can do this, let's do this. Let's do something exciting. Let's do something new. So I think the numbers are going to increase. And again, for me, the exciting thing is not the numbers increasing here for these marks. I want to see what's that one that we never thought was possible. The taste one didn't go forward, but that's a category. Well, maybe we're going to see a taste mark that does register. Or again, here's one that we never thought of. Wow, an application for it.
I'm really curious about the Stevie Wonder Braille mark. I don't know if you know the details of the application, but in my mind it would almost be treated like a foreign language mark. And if the average consumer would translate it or not, isn't the registration of that mark precluding other companies from registering Braille, because the average consumer would feel Braille on like the hand tag for clothing, and they're not going to know whether that means Stevie Wonder or not. So now other companies maybe can't use Braille for clothing, despite what it translates to.
Right. Okay, so just repeating the question for the video. So we showed the Stevie Wonder mark that was actually his name in Braille. And she's asking, well, you registered that, but isn't that precluding other people from registering Braille marks? Because the reality for most of the consuming public, we would know, okay, there are raised dots, and we would probably know enough to say, I think that's Braille, but it's very unlikely that any of us in this room would say, well, not only is it Braille, it's Stevie Wonder. So in terms of the trademark analysis, how are we going to do that? How are we going to say, oh, is this mark similar to this mark? To us, they're kind of just both Braille. And that's a really interesting question. What I don't know is whether subsequent to that, we in fact had any other filing that's been in Braille and what the analysis was. I'm thinking, some people get I'm jumping track here, but work for me just a moment. Under the likelihood of confusion analysis, where we're looking at whether the marks are similar, if you have a mark such as lupo, and then you have the mark wolf, well, lupo in Italian means wolf. But I think our analysis is predicated on the fact that, well, there's a large segment of the population that in fact speaks Italian, and they translate lupo into wolf. So we say those marks are similar. I don't know what we would do with the analysis of saying, well, what is the consuming public and their experience with Braille, and would they say those marks are similar, or at best most people would just say, well, these are two, hang tags that have raised dots on them. I'd have to read, but interesting question. So, and quite honestly, that's the kind of question. Oh, I don't want to say it keeps me going each day, but you always think you've considered I've been in this field for 33 years that I've seen everything, I've thought of everything. Never thought of that issue. So I'm not going to rush home to research it, but interesting question.
Have you ever encountered violence for trademark for a body movement? Because in Europe, I've seen professional footballers, athletes. They would trademark their own goal celebration, and then these goal celebrations would seem, at least for public, for the football fans, they would say as soon as you see this celebration, you know that this comes from a specific athlete.
Right. So he's asking about specific body movements, and his example was a celebration in the end zone. I'm pretty sure I'm not going to try to do this, but Tim Tebow, I'm pretty sure, was it just the kneel? An application was filed for that. Not 100% positive of that. Sometimes I had to be careful because in the public press there will be some representation. It will say, oh, and Tim Tebow is trying to register, this particular mark. And the reality is, no, he didn't actually file for that. Okay, so you have to be careful when I say, oh, yes, I always want to go back to see, oh, was there truly an application for that, or is that the press using terms, not really in the true USPTO? They'll just say, oh, that's the Tim Tebow trademark. Well, it may or may not be in terms of an actual application for a mark.
So would those entertainers say, some dancers and singers, they perform, they have their trademark dance moves, or would they ever file to trademark?
And I don't know if anyone has. Again, it's in part easy for us to say that, oh, did Michael Jackson try to trademark the moonwalk, even though he wasn't quite honestly the first to actually do that dance move. But I don't know whether we have any. But again, in terms of that analysis to say, well, would that be possible? I think it would be possible. I don't know whether we've had any, but I can't just summarily say, oh, that would never, ever be registrable. Based on some of the other things that we've seen, I think it could be.
At some point, do you run into these being functional parts of the product rather than marks? Taste, for example, on a drug could be a functional part of the drug rather than so it can be palatable and taken rather than being a mark.
Right.
Or
So
smells or
he's asking the functionality. That's certainly a part of our analysis. Color, for example, orange, where this is something to promote safety, we would say that serves an actual function. It's just not an arbitrary color the public recognizes orange related to a safety aspect. It does serve a function, so we would not register that. Taste, certainly things that normally have a taste. Again, as you said, it might make it more palatable. We would say that is serving a function. It has to be a taste that you would say, well, there was no reason for it to taste like this. Now it does. They're trying to use it as a source indicator. But certainly we always do look in our overall analysis the functional possible aspect. And if it's truly functional, unlikely it will not be registrable.
I have a question about Coca-Cola. I'm looking at the Coca-Cola bottle and I see red. So I'm an average consumer and I shop at Walmart or other supermarkets. And when I go in to buy cola, every single can of cola has a red color. Every brand. And my wife says, let's buy some Coke, and I just grab, here it is, it's Walmart brand, it's in a red can, and I put that in my wagon, and I buy it. I bought Coke. And the question I'm getting at is, are those other producers free riding on the red color which is associated with the original Coca-Cola brand, trademark?
Okay, so he's talking about the situation, and I'm sure we've all been there. You go into a store, and perhaps you're even in a hurry, okay, and so you're so used to seeing, oh, the Coca-Cola red, and oh, you just kind of grab it, and you get home, and as your wife's, what did you buy? I wanted Coca-Cola. I didn't want this. They are absolutely assuming that's what will happen to you. Okay? It's not like, oh, they had a lot of other colors they could have used and they just happened to settle on the color red. Okay? They absolutely want to try to make you think that you're getting a Coca-Cola product because red is ingrained. Okay? They're trying to get as close as possible. And if you go into what is back home, it's like Walgreens, I don't know what you have here, or CVS, a pharmacy. Have you ever looked at the drug packaging, for example? How similar, I want to say, the real one looks, and then there's another one. They look so close. Particularly if you're already sick, you're kind of hazy, and you just kind of get this one. That's what they're trying to do. Absolutely.
Yeah, back to that question. If the real use one, the trademark, the company's real use one is not different, sometimes public hard to connect the real use one to the registered one. So the companies, how do we interpret the company's the trademark? How do we think they trademark right? If a company owns a trademark like UPS, sometimes we just show the PowerPoint pictures and like Tiffany's blue color, but sometimes people have to connect the color with the registered one. So who is the real right for a trademark? Sometimes I think the right should be the registered one.
Well, the rights always are with the party that has the registration. I mean, that's the reason to try to register a mark, because that establishes prima facie evidence that in fact you are the owner in all of the 50 states and its territories. That's why you bother to get a registration. I'm sure you're aware that through use alone, you have what's known as common law rights. Okay? There's no requirement in the US that you seek federal registration. Through use alone, you have common law rights. Those rights can be very strong. But again, registration gives you something that you can't get through common law. Again, the most important thing is prima facie evidence of ownership. How does that come into play? Well, let's say that you're in a dispute with another party and you end up in court. You're able to take your registration certificate and as a matter of evidence, you present it to the judge. Not all judges, quite honestly, are well versed in trademark law. So you're not trying to fool the judge. You're not even making an argument. You're simply, as a matter of evidence, saying, Judge, I would like you to consider this. The judge will look and say, well, at the top it says United States Patent and Trademark Office. Where it says owner, it has your name. There's this beautiful gold seal. You must be the rightful owner. At that point, you're not going to raise your hand and say, don't you want to consider their superior common law rights? You're going to be silent. You can win based on having that registration. The other important thing, the registration, it gets you into our database. So if someone is starting out and they know to search our database, they're going to find you. Hopefully they'll say, darn, someone already has the mark that I wanted for related goods or services. I better choose a different mark. You didn't have to do anything at all. You didn't have to take them to court. They went away because they found your registration that established you as the rightful owner.
I have a follow-up question on that. I think the question is more about the scope of the registration.
Yeah.
So
I wasn't sure I
let me
understood the question,
rephrase.
sorry.
I think so. The question is directed from the perspective of an attorney running a trademark search who maybe has a sound mark, or that's maybe a scent mark, or and finds another mark and cannot ascertain the parameters of the mark drawing based on, as you say, it's lost in translation in the mark drawing and the mark description. So another way to pose that question, maybe from the PTO's perspective, is if you're an examiner and you have a new scent mark or some other non-traditional mark coming in, and you need to search it against your existing marks. Normally, the registered mark has certain presumptions built in based on the mark drawing and the idea of goods and services. And the examiner is not allowed to dig deeper to see how the mark is actually used in, say, the specimen, or if there are any limitations. The mark is presumed to have greater, protection, if you will, because if the limitation isn't written into the registration, it's not there. So when you have to describe the mark as a strongly scented plumeria blossom, and you get in, and that's a registered mark, and you get a new application in for a plumeria blossom, how are you going to know if it's the strongly scented plumeria blossom or just a subtle, pleasant plumeria blossom, or if this particular plumeria blossom is similar to a tulip blossom? And how would that examiner treat the scope of that registration, and would it be an exception to the rule that the examiner can't dig deeper in ex parte?
What a question. Okay. I would say plumeria is plumeria is plumeria. Okay. In the same way that color, we kind of go color families, that be it pink, red, scarlet, those are all kind of in the red family. We're going to say those are confusingly similar versus red compared to blue. We're going to say those are different colors. I think particularly for the non-traditional marks, this is where we're allowed to dig deeper because we can't understand what the mark is. It's very difficult from that mark description to really visualize or to hear. I think this is where the internet has changed the game a little bit. It wasn't so much before that we absolutely were prescribed from doing it, we didn't have a mechanism for doing it. Okay? We had a paper application, and there was this description. That's all we could work from. I think now, because of the internet, it's so easy to do a search that I can actually see what is the true motion there. Obviously, the internet's not going to help me for a scent mark, but I think examiners so much more today, they use the internet as a research tool. We can dig a little deeper only because we're so limited by what we have through the application itself.
In case of foreign applications under Section 44 or 66, how would you analyze such marks for distinctiveness, considering that we don't have to prove use in US for initial registration, and also considering that some non-traditional marks cannot be registered without acquiring secondary meaning?
So her question relates to the fact that we're able to register marks in the US based on a foreign registration, and because it's based on the foreign registration versus actual use in commerce in the US, how are we able to establish distinctiveness? What a great question for the professor.
Well, the examiners will be addressing distinctiveness, looking at the claimed mark and the ID. And so what you're basically saying is, if you file under 44 or 66, there's no specimen. So I think if the examiner were faced with a mark description or mark drawing that left a lot of questions as to what exactly was the mark, then I suspect the examiner would exercise his or her ability to do a request for more information in order to address the distinctiveness issue, and therefore would issue an office action requesting effectively a specimen. That's my assumption, but I'm not an examiner.
Well, because I think you're correct. We're going to be faced with the situation that it does register in another country, and each country has their own trademark laws and rules, and so this may be absolutely acceptable in, let's say, Australia. Okay? They don't even have a descriptiveness refuse. I'm just making this up. When it comes to us and we look at it and say, well, yes, this is clearly descriptive, we're going to have to make the refusal. And so their only option, they can't argue distinctiveness based on a registration. It can only be distinctive based on actual use in the United States. So they might be able to show that even though they didn't base it on use in commerce, it's possible that they actually do have sales in the US, but at the end of the day, they're going to have to show through the US consuming public that it has become distinctive. And they may or may not be able to do that. I think that's sometimes confusing to people, that if it registers elsewhere, that it automatically can register here, and that's simply not the case. So, in the back, that last question.
Yes. One of the requirements to grant a trademark is the graphic representation. How it works in some trademarks? What is the graphic representation of?
Well, there are exceptions for certain marks. And in fact, what it will say in the application is no drawing. Usually the drawing is the representation, but for the scent mark, the sound mark, what it actually, the code there is no drawing, and then you have to rely on the description. That's why for the NBC chimes, all I had there was that description of the notes, and asked you, well, can you figure out what that is? Again, that's where it's a little tricky sometimes. Like, again, if you're not at all musical, that reference to C and F and G or whatever it was, it will mean nothing to you. Yet if you hear me go do do do, that's okay, I guess. Maybe I could roar like a lion a little better. I don't know, but you know what that mark is. So. I think that's going to be it. I thank you for your time. It was a pleasure to be here.